Time for Night Court. We pass no judgment on these stories, but present them to you, the jury, for your consideration. First on the docket this evening, a routine traffic stop in Washington results in DUI charges. The offending driver challenges the case all the way up to the state Supreme Court, claiming that being pulled over for his initial offense of failing to use a turn signal was invalid. Time to bring in tonight's Legal Eagles, criminal defense attorney David Bruno and Washington Times legal affairs reporter Alex Swoyer. Great to have you both. Exhibit A. Washington state law on turn signals: a signal of intention to turn or move right or left when required shall be given continuously during not less than the last 100 feet traveled by the vehicle before turning. Alex, your thoughts?
The problem here with this law is modern technology. For example, with new cars, there's sensors that go off when you cross into a turn lane. For example, if I was going to go right, I could signal that I'm getting into the right lane, and then my turn signal would automatically go off before I actually turn. And so I think what that could lead to is patrol officers subjectively having to decide when and when not to stop drivers and issue tickets. And what we want with the law is to everyone to be treated uniformly. And so I think that this could lead to problems in the future and tickets not being handed out, equally.
Exhibit B, Washington Supreme Court, because the words "when required" were used, lawmakers contemplated circumstances when turn signals are not required. David, your analysis of this blinker battle.
Yeah, well, this is a state case, so every single state has a different rule and regulation when it comes to turning. But for here, they interpret that to mean when somebody is in the left-hand turn lane, it does require them to have the single turn. And I agree with the analysis. Actually, this is a very common constitutional analysis for most car cases, because police have to have a reasonable, articulable suspicion to stop vehicles, because it's considered a seizure under the 14th Amendment. So here, this was the issue, because later what happens is he's arrested, brought down to the station, and he blows a .26, which is a rather high number. Sure. So the defense attorneys attacked the stop, because if it was an unconstitutional stop, it would have been a win to get the DUI dismissed.
All right, Exhibit C, defendant's attorney to the Seattle Times, Brown's attorney Randall Jamison Jr. said the ruling, quote, allows for what most people would think are chippy or bogus stops by police. Final thoughts, Alex first, then David.
Yeah, and what David got into is exactly what a defense attorney would go to. They want to try to throw all the evidence out. And, I think it is fair to say that, again, you're going to have to look at how the distance, and the patrol officer is going to have to prove, was it 100 feet. And I think it could get a little wonky there, and you could have it applied differently to different drivers. And that's not something we want to see. Quickly,
David, so we can go on to the other topic.
Yeah, sure. This is just one example of why police get stopped. I mean, look at some of the other more arbitrary things like careless driving or reckless driving. So there's always going to be a reason, and this is where it's important to get the right attorney to challenge these stops if it's an automobile case.
Exhibit D from the Los Angeles Times, suggesting Louisiana alligator farmers are getting ornery with a California ban. Louisiana officials say the alligator industry pumps $80 million a year into the state. Trappers collected 15,052 alligator skins in 2017, while farmers harvested 382,000 plus alligators valued at more than $70 million, including the meat, according to the Louisiana Alligator Advisory Council. David, your thoughts on the gators?
Yeah, tremendous amount of commerce, but I want to make an argument on the Supremacy Clause, because the federal government has regulated this. The alligators are not considered an endangered species, and the Endangered Species Act does regulate the commerce on these types of animals, and it allows it. So because the federal government has allowed it in the Endangered Species Act, California cannot regulate, and that's where I think the plaintiffs in this case will be victorious on the Supremacy Clause. Not to mention, there was a case in 1979, same state, same regulation. It was struck down as unconstitutional under that argument.
Exhibit E, Louisiana Attorney General Jeff Landry says, quote, if the California ban is allowed to go into effect, it would destroy the alligator industry and its jobs in Louisiana, Texas, Florida, Georgia, and California. Alex, where are you on the gator issue?
You know, the 1979 case is good precedent that it does favor Louisiana. However, I think that California could point to a recent move by the Supreme Court, which was not to hear a ban out of the same state on foie gras, what we call in Texas duck liver. And so lower court had said that the 2012 law could go in place, so you can no longer order duck liver in California, and the Supreme Court decided not to hear it. So if they can point to that same type of analysis and say here the same thing should apply to gator skin, then maybe California could end up on the winning side.
All right, Alex, David, thanks very much. David, I better not see you wearing those gator skin boots.
You got it, Mike.
Have a wonderful weekend.
Happy New Year to all.